The phone rings. Unknown number. You hesitate, your stomach tightens, and you already know what this is. A debt collector. Maybe it's your first call. Maybe it's your 50th. Either way, it never gets easier. The tone, the pressure, the fear, they all mix together until you start questioning everything. What can they really do? Can they sue me? Can they call my job? Can they tell my family? Let's make something clear right now. You have rights. Strong rights. Federal rights. And the people on the other end of that call are counting on you not knowing them. They're trained to use fear, urgency, and confusion to get you to pay before you think. But once you understand how this system actually works, the power shifts. Before we dive in, quick note. This is general information about federal law and common practices, not individual legal advice. Specific laws can vary significantly by state, so always verify local rules when making decisions about your situation. In the next 40 minutes, I'm going to expose exactly how the debt collection industry operates in America, what third-party collectors can and cannot legally do under the Fair Debt Collection Practices Act, and the smart moves that protect you from the first phone call to the courtroom if it gets that far. Have you ever been contacted by a collector before? Tell me in the comments, what was your experience like? Were they polite, or did they cross the line? Your story might help someone else watching right now, so grab a notebook, turn off distractions, because this might be the most important financial education you ever get. Let's begin. How the debt collection industry really works. When you owe money and stop paying, most banks don't chase you forever with their own employees. They have better things to do. After your account hits about 180 days delinquent, 6 months, they typically charge it off. That's an accounting term that means they write it off as a loss on their books. But the debt doesn't disappear. What happens next is where a massive, largely hidden industry takes over. Banks sell your debt in bulk to third-party companies for pennies on the dollar, sometimes as little as 3 to 8 cents per dollar owed. Think about that for a second. If you owe $10,000, a debt-buying company might pay the bank $300 to $800 for the right to collect that debt. They're essentially buying a lottery ticket. If they can get you to pay anything, even a fraction, they profit. If they get you to pay the full amount, it's a windfall. These companies are called debt buyers, and there are hundreds of them operating across the country. Portfolio Recovery Associates, Midland Credit Management, LV&V Funding, Cavalry Portfolio Services, and many others you've never heard of. This is a multi-billion-dollar industry. These companies buy debts, trade them, bundle them into portfolios, and sometimes sell them again to other buyers. Your debt might change hands 3 or 4 times. Each time it's sold, the documentation gets a little messier. Account statements get lost. Original contracts disappear. Payment histories become incomplete. And that's where your leverage begins. Because if they can't prove they own the debt with proper documentation, they can't legally collect it. That documentation requirement is built into federal law, and we'll talk about how to use it in a minute. Here's something third-party collectors will never tell you up front. They are not the government. They're not law enforcement. They can't arrest you. They can't send police to your door. They can't threaten you with jail time. Debt, especially consumer debt like credit cards, medical bills, and personal loans, is a civil matter, not a criminal one. The only debts that can result in criminal charges are things like tax evasion or deliberate fraud, and even those require the government to prosecute, not a private collection agency. But fear is their most effective collection tool, and they use it expertly. They use language designed to make you panic. They imply consequences they can't actually deliver. They create urgency where none exists. Their entire business model depends on you being scared and uninformed. Once you understand the rules, that fear starts to evaporate. The debt collection industry operates under strict federal regulations, primarily the Fair Debt Collection Practices Act, which was passed in 1977 and has been updated several times since, including significant updates through CFPB Regulation F in 2021. The FDCPA exists because Congress recognized that third-party debt collectors were engaging in abusive, deceptive, and unfair practices. The law sets clear boundaries, but it only works if you know what those boundaries are and how to enforce them. What third-party collectors can and cannot legally do. Let's get specific about your rights. Under the Fair Debt Collection Practices Act, third-party debt collectors, companies that buy debts or collect on behalf of others, not the original creditor, have strict limits on their behavior. It's important to understand that the FDCPA applies to third-party collectors, not to original creditors like banks or credit card issuers directly, though many original creditors follow similar standards to avoid state law violations and reputational damage. Here's what third-party collectors absolutely cannot do. They cannot call you before 8 a.m. or after 9 p.m. in your time zone unless you give them permission. If you work nights and sleep during the day, and they know that, calling you at 10 a.m. could still be considered harassment. They cannot call you at work if you've told them, either verbally or in writing, that your employer prohibits personal calls. Once you inform them of this, they must stop calling your workplace. They cannot harass you. Under CFPB Regulation F, more than 7 calls about a single debt within 7 days, or calling again within 7 days after a live conversation, is presumed harassing. This gives you a clear standard to point to. The regulation also governs other communication channels. Collectors must respect your preferred method of contact, and they're limited to limited content messages for things like voicemails and texts that might be seen by others. You can require in writing that all communication be by mail only. They cannot use obscene or profane language. They cannot threaten you with violence or harm. They cannot threaten to take actions they don't intend to take or can't legally take. For example, they can't say we're going to garnish your wages tomorrow if they haven't sued you and obtained a judgment. And they certainly can't threaten to have you arrested or prosecuted criminally for a civil consumer debt. They cannot lie to you. They can't falsely claim to be attorneys if they're not. They can't falsely claim to be government officials or representatives of credit bureaus. They can't misrepresent how much you owe. They can't claim you've committed a crime. They can't threaten arrest or tell you that not paying a consumer debt is illegal. All of these are explicit violations of the FDCPA. They cannot contact third parties about your debt beyond what's necessary to locate you. This is a big one. They can't call your family members, your neighbors, your friends, or your coworkers and tell them you owe money. They can contact third parties to try to find you if they've lost track of your location, but even then, they can only identify themselves by name, say they're confirming or correcting location information, and only reveal their employer if directly asked. They cannot mention the debt. They cannot say, your son owes us money, or we're calling about a debt. If they do, that's a violation. They cannot send you letters or leave voicemails that reveal to others that you're being contacted about a debt. So if they send you a postcard that says, urgent, collection notice, visible to anyone who handles your mail, that's a violation. If they leave a voicemail that says, this is a debt collector calling about your overdue account, and someone else in your household hears it, that could be a violation depending on the circumstances. They cannot continue contacting you after you've sent a written request to stop. This is called a cease and desist letter. After a written cease and desist, they may only contact you to confirm they'll stop or to notify you they intend to take a specific legal action, such as filing a lawsuit. We'll talk more about cease and desist letters later. They cannot ignore your request for debt validation. If you send a written request for validation within 30 days of their first contact, they must pause collection efforts until they provide verification. This is one of your most powerful rights. Now here's what they can do. They can contact you to collect a valid debt that you actually owe, and that's within the statute of limitations. They can send you letters. They can call you during permitted hours and frequencies. They can report accurate information to credit bureaus. And yes, they can sue you if they legally own the debt, have proper documentation, and the statute of limitations hasn't expired. The lawsuit threat is real, but it's also their most expensive option, and they only pursue it when they think they can win and actually collect. The problem is that collectors constantly blur these lines. They walk right up to the edge of what's legal, and many cross over into illegal territory regularly. They intimidate. They manipulate. They exploit ignorance. I've seen cases where collectors said, "We're sending paperwork to your employer for wage garnishment," when they hadn't even filed a lawsuit yet. Completely illegal. I've seen collectors tell people, "You'll be arrested if you don't pay by Friday." Completely illegal. I've seen collectors call a debtor's elderly mother and tell her that her daughter was avoiding her responsibilities and destroying the family's reputation. Completely illegal. These violations happen because collectors are often working on commission or bonuses tied to how much they collect. They're incentivized to push boundaries, and they're counting on you not knowing your rights or being too scared to enforce them. That stops today. How to take control from the first call. Here's the most important rule. Never talk to a debt collector without documenting everything. The moment you recognize it's a collector on the phone, grab a pen and paper. Write down the date and time. Write down the name of the person calling and the company they say they represent. Write down exactly what they say, as close to word for word as you can. If they make threats, write those down. If they tell you amounts or dates, write those down. This documentation becomes crucial if you need to file a complaint or sue them later. In many states, you also have the right to record the call. Check your state's laws. Some states are one-party consent states, meaning you can record a call you're part of without telling the other person. Other states are two-party consent states, meaning you need to inform the other person they're being recorded. If you're in a one-party state, record every call with collectors if you can. Use your phone's recording function or a recording app. If you're in a two-party state, tell them at the start of the call, "I'm recording this call for my records." Many collectors will be more careful about what they say once they know they're being recorded. When you pick up the phone, stay calm. Don't let them control the conversation with urgency or aggression. Here's what you should say, and this is almost like a script you can memorize. "I do not acknowledge this debt. Send me written validation as required under the Fair Debt Collection Practices Act. Do not contact me by phone again. All future contact must be in writing." That's it. You don't need to explain your financial situation. You don't need to tell them why you can't pay. You don't need to admit anything. In fact, admitting the debt can hurt you legally, especially if the statute of limitations is about to expire or has expired. Just say those words and then hang up if they keep talking. Once you've said that, they are legally required to stop calling and send you written validation. That validation must include the name of the original creditor, the company you originally owed money to, not necessarily the current collector, the amount owed, and verification that the debt collector has the legal right to collect this debt, which usually means documentation showing the debt was properly assigned or sold to them. This is called debt validation, and it's one of the most powerful tools you have under the FDCPA. Here's why. In many cases, debt collectors can't provide proper validation. Remember, these debts have often been sold multiple times. The original credit card agreement might be long gone. The detailed account statements showing every transaction might not have transferred when the debt was sold. The assignment documents proving the chain of ownership might be incomplete or missing entirely. When collectors can't validate, they're required to stop collection efforts. Once you send a timely validation request, the collector must pause collection until they mail verification. If they can't verify, they must stop collecting. For your credit report, file a dispute under the Fair Credit Reporting Act. If the furnisher can't verify the debt to the credit bureaus, the bureaus must delete the trade line. These are two separate processes. FDCPA governs the collector's behavior. FCRA governs credit reporting. But both work in your favor when documentation is lacking. Send your validation request in writing as well, within 30 days of their first contact. Send it certified mail, return receipt requested, so you have proof they received it. There are templates available. I'll link to them in the description. A simple letter says, I am writing in response to your contact about a debt you claim I owe. I am requesting validation of this debt as required under the Fair Debt Collection Practices Act, 15, USC 1692G. Please provide 1. The name and address of the original creditor, 2. The amount owed with an itemized accounting showing how the balance accrued, including principal, interest, and fees, 3. Verification that you have the legal right to collect this debt, including documentation of proper assignment, and 4, if applicable in my state, proof that you are licensed to collect debts here. Until you provide this information, you must cease all collection activities. All future communications must be in writing. Once they receive this letter, the clock stops on their collection efforts until they respond with proper documentation. This buys you time. It forces them to invest resources in proving their case, and in many instances, they simply can't, so the collection attempts stop. When collectors break the law and how you can win third-party debt collectors violate the FDCPA constantly. Studies have shown that a significant percentage of consumers report violations. The most common violations include calling outside permitted hours, calling too frequently, harassing or abusing consumers, threatening legal action they can't or won't take, contacting third parties about the debt, misrepresenting the amount owed, and continuing to contact after receiving a cease and desist letter. When a collector violates the FDCPA, you have the right to sue them in federal or state court. You can recover up to $1,000 in statutory damages per lawsuit, not per violation, but per case, even if there are multiple violations. You can also recover actual damages. Actual damages are things like emotional distress, lost wages if you had to miss work because of the harassment, or even medical expenses if the stress caused health problems. And critically, if you win, the debt collector has to pay your attorney fees and court costs. This means you can often find an attorney to take your case on contingency. You don't pay them unless you win. Real people win these cases every single day. A woman in Ohio was called 15 times a day by a collector for 2 weeks. She documented every call. She sued. She won $4,000, statutory damages, plus compensation for emotional distress. A man in California was told repeatedly by a collector that he would be arrested and jailed if he didn't pay immediately. He recorded the calls. He sued. He won $5,000 plus attorney fees. A woman in Florida had a collector call her workplace and tell her supervisor she owed money. She sued. She won $3,500. These aren't rare cases. Consumer rights attorneys handle these cases regularly. The FDCPA includes the attorney fee provision specifically to make it economically viable for consumers to enforce their rights. Without that provision, suing over a $1,000 violation wouldn't make sense because attorney fees would cost more. But with the fee-shifting provision, attorneys can afford to take these cases, and debt collectors face real financial consequences for breaking the law. If a collector violates your rights, here's what you should do. First, document everything. Save every voicemail. Keep a log of every call with date, time, and what was said. Save every letter and email. If you recorded calls, keep those recordings. Second, file a complaint with the Consumer Financial Protection Bureau at cfpb.gov. The CFPB investigates debt collectors and can take enforcement action. File a complaint with your state attorney general's office as well. Many states have their own debt collection laws that are even stricter than federal law. Third, consult with a consumer rights attorney in your area. Many offer free consultations. Bring your documentation. They'll evaluate whether you have a strong case. If you do, they'll often take it on contingency. You don't pay unless you win. The National Association of Consumer Advocates has a directory of attorneys who specialize in these cases. Search for one in your state. Don't let violations slide. When collectors break the law and face no consequences, they keep doing it. When they get sued and have to pay damages and attorney fees, they change their behavior. Your lawsuit doesn't just help you, it helps every other consumer that collector might have harassed. If you've ever reported a collector, or wanted to, but didn't know how, tell me in the comments. Your experience could help someone else take action. The lawsuit threat. When it's real and when it's not, collectors frequently use the threat of a lawsuit to pressure people into paying. And sometimes they do sue. But here's what you need to understand. Lawsuits are expensive for them. They have to pay court filing fees. They have to pay an attorney to handle the case. They have to invest time and resources in gathering documentation and proving their case. So they only sue when they think they can win and actually collect money from you afterward. If you have no job, no bank account, and no assets, you're what's called judgment proof. Even if they sued and won, they couldn't collect anything. So they probably won't bother suing. But if you have a steady job, a bank account with money in it, or property, you're a more attractive target for a lawsuit. It's also important to note, under federal law, collectors are prohibited from suing or threatening to sue on time-barred debt where the statute of limitations has expired. If they do threaten suit on time-barred debt, that's an FDCPA violation. If you do get sued, you'll receive a summons and complaint. This is a legal document that notifies you of the lawsuit and gives you a deadline to respond, usually 20 to 30 days, depending on your state. The summons will tell you where to file your response. The complaint will lay out the plaintiff's claims, who they are, how much they say you owe, and why they believe you owe it. Here's the critical part. Do not ignore this document. I cannot stress this enough. Ignoring a lawsuit is the worst thing you can do. If you don't respond within the deadline, the collector wins automatically by default judgment. That judgment becomes a court order saying you owe the money. With that judgment, they can garnish your wages, levy your bank account, or place a lien on your property depending on your state's laws. Wage garnishment rules vary significantly by state. Federal law generally caps wage garnishment at the lesser of 25% of your disposable earnings, or the amount by which your weekly disposable earnings exceed 30 times the federal minimum wage. However, some states provide stronger protections and allow less than 25%. A few states, Texas, North Carolina, Pennsylvania, and South Carolina, don't allow wage garnishment for consumer debts at all, except for child support, taxes, and student loans. Beyond wage garnishment limits, states also have different rules for bank account levies and exemptions that protect homestead equity and personal property. Know your state's specific rules. But if you respond, even with a simple written answer, you change everything. Your answer should deny their claims and demand that they prove their case. You can also raise affirmative defenses, which are legal reasons why they shouldn't win, even if the facts are as they claim. Common affirmative defenses include the statute of limitations has expired, they lack standing because they don't actually own the debt, the amount they're claiming is incorrect, or they violated the FDCPA in their collection efforts. Here's a basic template for an answer. Defendant denies all allegations in the complaint and demands strict proof thereof. Defendant further asserts the following affirmative defenses. 1. The alleged debt is barred by the applicable statute of limitations. 2. Plaintiff lacks standing to sue as it has not provided proof of ownership of the alleged debt. 3. The amount claimed is incorrect and unsupported by documentation. Defendant demands that plaintiff provide the original signed credit agreement, a complete account statement showing how the alleged balance accrued, and proof of assignment showing plaintiff owns this debt. When you file this answer, you're forcing them to prove their case. And here's the secret. Many debt buyers can't. They bought your debt in a portfolio with thousands of other accounts. They have a spreadsheet with your name and a balance. But they don't have the original credit card agreement you signed. They don't have detailed transaction histories. They don't have clear assignment documents proving they own the debt. When you demand proof, they often can't provide it, and the case gets dismissed or they offer a low settlement. If you can't afford an attorney, look for legal aid organizations in your state. Many provide free help with debt collection lawsuits for low-income individuals. You can also represent yourself. It's called appearing pro se. Many courts have self-help resources and forms for pro se litigants. It's not ideal, but it's better than not responding at all. Responding to a lawsuit also gives you leverage to negotiate. Once they realize you're not going to roll over, they'll often settle for less than they're claiming. Maybe they were suing you for $10,000, but they'll settle for $4,000. That's still a terrible deal if the debt isn't valid or the statute of limitations has expired. But if you genuinely owe it and the debt is enforceable, a settlement can be a way to resolve it. If you settle, get it in writing before you pay a cent. The settlement agreement should state the exact amount you're paying, that this payment resolves the debt in full, and that they'll file a dismissal of the lawsuit with the court. Get all of this signed by both parties before you send any money. Also be aware, the amount of debt forgiven in a settlement may be considered taxable income by the IRS, and you could receive a 1099-C form. There are exceptions, for instance, if you were insolvent at the time of settlement, so consult with a tax professional if you're settling a significant amount. Statute of limitations, the silent trap. Every state has a statute of limitations on debt. This is the time period during which a creditor or collector can legally sue you to collect. It varies by state and by type of debt, but for credit card debt and most consumer debts, it typically ranges from 3 to 6 years. A few states have shorter periods, a few have longer, but most fall in that range. The clock usually starts from the date of your last payment or the date of last account activity, depending on how your state's law is written. After the statute of limitations expires, the debt becomes time-barred. That doesn't mean the debt goes away. You technically still owe it, but the collector can no longer sue you to collect it. If they try to sue you on time-barred debt, you can file a motion to dismiss based on the expired statute of limitations, and the court will throw the case out. Moreover, under federal law, collectors are prohibited from threatening to sue on time-barred debt. But here's the trap, and it's a big one. Whether a small payment or acknowledgement resets the clock depends on your state. Many states require a payment or a written acknowledgement to restart the statute of limitations, though in some states even a verbal acknowledgement might restart it. Don't pay or admit anything until you confirm your state's specific rules. Suddenly, the clock could start over, and they'd have another 3 to 6 years to sue you. This is why collectors love to call about old debts and say things like, just pay $20 today to show good faith, or if you can just acknowledge this debt in writing, we can work out a payment plan. They're trying to restart the clock. Before you pay anything on an old debt, before you acknowledge anything, check your state's statute of limitations. Find out when you made your last payment. If the statute has expired, you need to be very careful. If a collector contacts you about time-barred debt, you can send them a letter that says, I have received your communication regarding an alleged debt. I believe this debt is beyond the statute of limitations in my state. If you are threatening to sue me, you should be aware that I will raise the statute of limitations as an affirmative defense, and such threats on time-barred debt may violate the FDCPA. I do not acknowledge this debt. Some states have laws that prohibit collectors from even attempting to collect on time-barred debt in certain ways. Other states allow them to ask, but they may have to disclose that the debt is time-barred and they can't sue. Know your state's rules. If you do want to pay an old debt, maybe for moral reasons, maybe to clean up your credit, at least negotiate. If it's time-barred, they have zero leverage. They can't sue, so they should be willing to settle for a fraction of the balance. Get any settlement agreement in writing before you pay, and make sure it states clearly what you're paying and that it resolves the debt in full. And remember, the statute of limitations on lawsuits is separate from how long the debt can stay on your credit report. Credit reporting is governed by the Fair Credit Reporting Act, which says most negative items can stay on your report for 7 years, from the date of first delinquency. So a debt can be too old to sue on, but still legally appear on your credit report. These are two different timelines under two different laws: settlements, credit reporting, and pay for delete. If you're negotiating a settlement with a collector, there are a few important things you need to understand beyond just getting the amount reduced. First, let's talk about how settlements affect your credit report. When you settle a debt for less than the full amount, it will typically show on your credit report as settled, or settled for less than the full balance. This is still a negative mark, though it's generally viewed as better than an unpaid collection. The account will remain on your report for 7 years from the date of first delinquency. Some consumers try to negotiate what's called pay for delete, an agreement where the collector removes the negative item from your credit report entirely in exchange for payment. Here's the reality. Pay for delete deals are possible, but rare. Many data furnishers are bound by agreements with the credit bureaus that don't allow them to delete accurate negative information. The credit reporting system is supposed to reflect your actual credit history, including negative items. Some smaller collectors might agree to pay for delete, but don't count on it as standard practice. If a collector does agree to it, get it in writing before you pay. More commonly, you can negotiate how the account will be reported. For example, you might get them to agree to report it as paid in full rather than settled if you pay a certain percentage. Or you might get them to stop reporting it as unpaid once you complete a payment plan. Any agreement about credit reporting must be in writing in your settlement agreement before you send money. One more critical tax issue. When a creditor or collector forgives more than $600 of debt, they're required to send you and the IRS a 1099-C form reporting the forgiven amount as income. The IRS generally considers forgiven debt to be taxable income. So if you owed $10,000 and settled for $4,000, that $6,000 difference might be taxable. However, there are exceptions. If you were insolvent, meaning your total debts exceeded your total assets, at the time the debt was forgiven, you might not owe taxes on it. You'd need to file IRS Form 982 with your tax return. This can get complicated, so if you're settling a substantial debt, consult with a tax professional to understand your obligations. Protecting your mental health and peace of mind. Let's take a step back from the legal technicalities for a minute and talk about something equally important: your mental and emotional well-being. Dealing with debt collectors is not just a legal problem, it's a psychological one. The constant calls, the threatening letters, the feeling that you're being hunted, it wears on you. It affects your sleep. It creates anxiety. It makes you dread checking your phone or your mail. For some people, it leads to depression, panic attacks, or even thoughts of self-harm. I need you to hear this. You are not a bad person because you have debt. You are not a criminal. You are not worthless. You are a human being dealing with a difficult financial situation, and you deserve to be treated with dignity and respect. The shame and guilt that debt collectors try to create in you is a manipulation tactic. It's designed to make you feel so terrible that you'll pay just to make the feeling stop, even if you can't afford it. But debt is not a moral failing. Life happens. People lose jobs. People get sick. Medical bills pile up. Businesses fail. Relationships end and finances split. The economy crashes. These are systemic issues, not personal character flaws. And even if you made mistakes, even if you overspent or mismanaged your money or made poor financial decisions, that doesn't make you a bad person. It makes you a person who made mistakes, like literally every human being on the planet. The debt collection industry profits from your shame. They want you to feel like you're alone, like you're uniquely broken, like everyone else has their financial life together except you. But that's not reality. Millions of Americans are dealing with debt collection right now. Millions more have been through it and come out the other side. You are not alone. If the stress is becoming overwhelming, please reach out for support. Talk to someone you trust: a friend, a family member, a therapist. Many communities have free or low-cost counseling services. The 988 Suicide and Crisis Lifeline is available 24/7 if you're having thoughts of harming yourself. Financial stress is a real and serious issue, and there are people who care and who can help. Your life has value beyond your credit score or your bank balance. Also, set boundaries with collectors to protect your peace. You have the legal right to tell them to stop calling. Exercise that right if the calls are causing you distress. Send a cease and desist letter. I am requesting that you cease all communication with me regarding this alleged debt. Under the Fair Debt Collection Practices Act, after receiving this written request, you may only contact me to confirm you are stopping contact or to inform me of specific legal action you intend to take. Send it certified mail. Once they receive it, they can only contact you for those two limited purposes. Yes, stopping their calls means you won't know if they're planning to sue, but you can weigh that risk. If you're judgment-proof, it might not matter. If the statute of limitations has expired, they legally can't sue anyway, and your mental health matters more than knowing every move they're making. Sometimes the healthiest thing you can do is cut off contact and deal with consequences if and when they arise. You can also set up your phone to block unknown numbers, or use apps that screen calls and block known collector numbers. You can set up a separate email address just for dealing with collectors so they're not flooding your main inbox. You can use a P.O. box for mail, so you're not dreading your home mailbox every day. These are practical steps that give you back some control and reduce daily stress. Remember, you are fighting a system that was designed to overwhelm you. The fact that you're here, learning your rights, educating yourself, that takes courage. That's strength, not weakness. You're taking back power, and that matters. What to do right now? Your action plan. Let's bring all of this together into a concrete action plan you can start implementing today. If you're currently dealing with debt collectors, here's what you should do, step by step. Step 1. Document everything. Create a file, physical or digital, where you keep every piece of correspondence from collectors. Every letter, every email, every voicemail. Keep a log of phone calls with date, time, company name, collector name, and what was said. This documentation is your evidence if you need to file a complaint or sue for FDCPA violations. Step 2. If you haven't already, send a debt validation letter to every collector who has contacted you, as long as it's within 30 days of their first contact. Use the template I mentioned earlier. Send it certified mail, return receipt requested. Keep a copy for your records. This forces them to prove they own the debt and pauses their collection efforts in the meantime. Step 3. Check the statute of limitations for each debt. Find out when you made your last payment on each account. Look up your state's statute of limitations for the type of debt. Calculate whether the statute has expired. If it has, do not make any payments and do not acknowledge the debt. If collectors contact you about it, inform them in writing that you believe the debt is time-barred and that threatening suit on such debt may violate federal law. Step 4. Review your credit reports. Pull your reports from all 3 bureaus at annualcreditreport.com. You can do this weekly for free. Look for accounts and collections. Check the dates. Check the amounts. Look for errors. If there are debts listed that you don't recognize, or amounts that are wrong, or accounts that should have aged off after 7 years but are still there, dispute them through the FCRA process. The bureaus have to investigate and remove anything they can't verify. Step 5. Decide on your strategy for each debt. Is it within the statute of limitations and clearly valid? Then you might need to settle or pay it. Is it time-barred? Then you can likely ignore collection attempts safely or negotiate a very low settlement with no leverage on their part. Is the documentation questionable? Then demand validation and be prepared to fight. Is the collector violating the FDCPA? Then document the violations and consider filing a complaint or consulting an attorney about suing. Each debt might require a different approach. Step 6. If you're sued, Respond. Do not ignore it. File an answer within the deadline. Demand that the plaintiff prove their case. Raise affirmative defenses including statute of limitations, lack of standing, and improper documentation. If you can't afford an attorney, look for legal aid or represent yourself. But respond. That's the most important thing. Step 7. Set boundaries to protect your mental health. If the calls are too much, send cease and desist letters. Block numbers. Set up spam filters. Give yourself permission to take care of your emotional well-being while you deal with this situation. Step 8. Know when to get help. If you're overwhelmed, talk to a nonprofit credit counseling agency. They're different from debt collectors and exist to help you create a plan. If collectors are breaking the law, talk to a consumer rights attorney. If you're considering bankruptcy, talk to a bankruptcy attorney. Don't try to handle everything alone if you need help. And throughout all of this, remember, you have rights, you have power, you have options. Collectors win when you're scared and uninformed. You win when you're educated and strategic. When to fight and when to settle. Not every debt is worth fighting. Sometimes the smart move is to settle and move on. Other times, fighting is absolutely the right call. How do you know the difference? Fight if the debt is time-barred. If the statute of limitations has expired, they can't legally sue you, and threatening to do so violates federal law. You have no reason to pay unless you want to for personal reasons. If they do sue, you'll win by raising the statute of limitations as a defense. Fight if they can't prove they own the debt. If you've demanded validation and they can't provide proper documentation showing they own the debt and the amount is correct, push back. Don't pay a debt that isn't proven. Fight if the amount is wrong. Collectors sometimes inflate balances with improper fees or interest that isn't legally owed. If the amount they're claiming is significantly higher than what you remember owing, demand an itemized accounting showing exactly how the balance accrued, principal, interest, fees, everything, and challenge incorrect charges. Fight if they've violated the FDCPA. If they've harassed you, lied to you, threatened you illegally, contacted third parties about your debt, or called excessively, you may have a claim against them. Consider suing them rather than paying them. Settle if the debt is valid, within the statute of limitations, and they have proper documentation. If you genuinely owe it, and they can prove it, fighting might not get you anywhere. In that case, negotiating a settlement for less than the full amount is often the smart move. Settle. If you're facing a lawsuit, you'll likely lose, and the alternative is wage garnishment or bank levies. If they're going to win in court and take 25% of your paycheck or whatever your state allows, settling for 50 to 60% of the balance and avoiding the judgment might be better. Settle if paying a reduced amount gives you peace of mind and closes the chapter. Sometimes it's worth paying something just to be done with it, even if you might have been able to fight it. That's a personal choice based on your stress level and priorities. When you do settle, negotiate hard, start low, offer 25 to 30% of the balance. They'll probably counter higher. You might land somewhere between 40 and 60%. For time-barred debt or debt they can't fully validate, you can go even lower because they have less or no legal leverage. And no matter what you agree to, get it in writing before you pay. The settlement agreement should state the exact amount you're paying, that this resolves the debt in full with no remaining balance, that they won't sell any remainder to another collector, and how they'll report it to credit bureaus. Don't trust verbal promises. Don't send money without a signed written agreement. Protect yourself. Final thoughts. You have more power than you think. Here's the bottom line. The debt collection system is designed to intimidate you into paying quickly without thinking. Third-party collectors use fear, urgency, and your own lack of knowledge against you. But that only works if you don't know your rights. Now you do. You know they can't threaten you with arrest. You know they can't call you at all hours or excessively more than 7 times in 7 days about a single debt. You know they can't harass your family. You know you have the right to demand validation. You know you can tell them to stop contacting you, and they can only reach out to confirm they're stopping or notify you of specific legal action. You know you can sue them if they violate the law. You know about statutes of limitations and how payments or acknowledgments can restart them in many states. You know how to respond to a lawsuit. You know when to fight and when to settle. You know about tax implications of settled debt and the reality of pay-for-delete agreements. This knowledge is power. It shifts the dynamic. You're no longer a scared person hoping the calls will stop. You're an informed consumer enforcing your legal rights. That's a completely different position. What would you do if a collector called you right now? Would you know how to handle it? Drop a comment and tell me, what's the one thing from this video that changed how you'll approach debt collection calls in the future? If you found this video helpful, subscribe. Next week, we're covering how to rebuild your credit after collections, charge-offs, or bankruptcy. I'll show you the specific steps and realistic timelines for getting back to a healthy credit score. And if you need resources, debt validation letter templates, cease and desist letter templates, state-by-state statute of limitations charts, links to file CFPB complaints, directories of consumer rights attorneys, they're all in the description below. Everything is free. Use them. One final reminder. This is general information about federal law and common practices, not individual legal advice. Laws vary by state, and your specific situation may require professional guidance. When in doubt, consult with a licensed attorney in your jurisdiction. Thank you for watching. Thank you for taking control of your financial situation instead of being a victim of it. That takes courage. Now go. Document those calls. Send those validation letters. Know your rights. Enforce your rights. You are not powerless. You never were.